So just want to try and show you, if it's possible, in a diagram of what's happened with the right to petition, right? Some major, well, they actually don't affect it illegally. It's some new things that have been, I would say, added to it because you can't really change the right and the core judicial authorities of the House of Commons itself to receive petitions because they're still in standing orders, right? What is best to say to understand it is they made alternative processes and people just stopped using it. And these alternative processes, you're investing or trusting in these new figures who've been invented, like the House of Commons Commissioner and the Parliamentary Health Service Ombudsman, and then the courts for election petitions. And, those are all funded. And you may send complaints in, but the whole point in the whole legal process of those is that we have substantial rights that come part and parcel with that because it's a lawful process. Just like when, barristers and lawyers go to court and do legal cases, but they don't do as much work out and about because it costs money and they charge more money. But solicitors and lawyers can go on site and get evidence and even get courts to direct the police to go do it, right? Whether you trust the police or not, if you're opposing the police in a case. But it's like the police themselves, right, are a legal process. And there's a lot of legislation around the police regulating them, but there isn't a lot of legislation around regulating this, right? And that's the problem. And as the police have got huge and massive, and they've got a lot of powers, and no one else does private prosecutions really anymore. They've been left to their own devices, and they take it really seriously, the criminal process, and they end up bossing people around and making out like it's the be all and end all and it's the only thing, but it's actually not. And when you take a matter very serious to Parliament, you are overriding the police and going higher and taking up authority yourself, and this is something that they don't seem to be able to reconcile. So I don't know how long this is going to record for if the memory card fills up, but I'll try and get it down. Now, I'm reading through the committee reports, and I've got a few to read yet, and I've kind of been putting it off for a while, getting them read. But it's taking me forever because every paragraph that I read, there's either something to criticise or something to write about, or it triggers me to go and research and find out more. So I'm like stopping every paragraph or two just to go and, it might even put me off for the whole day. But what I'm finding generally is these parliamentary committee reports they're propaganda machines. They're actually absolutely, completely and totally full of political propaganda to our disadvantage and to the MP's advantage, to the main political party's advantage, to mislead us, right? When actually, what is that based on? Well, actually, they say that, there is, Parliament can make up its own law, but it's set in writing in standing orders, but they've started to make all these ridiculous policies which aren't even properly voted through, and they're only signed off by Tom, Dick, or Harry, some leader of the House of the chairman of a committee or something, and they're just rules which they impose, but aren't actually any proper true law, and they can't. What you'll find is our rights are actually set in law. That's why they made the 1688 Bill of Rights, and we've got observation of due process of law as well. Our rights are set in legislation, in constitutional and statute, and that is our part of the processes. And then once you hand it into Parliament, you pass it over, and then it's like yin and yang, right? And the yin is trying to make yang obsolete, but it can't because you need both of them, right? Yin cannot cancel out yang, right? And yang cannot cancel out yin. It exists together, right? And that's what Parliament are trying to pass off as what they're doing, but they're failing dramatically. And they're just misleading. But let me just like sort of do this diagram, right? I don't know which way is the better way to do it. So if the battery doesn't run out, right? So we know that it goes all the way back to the Witten meetings of the Anglo-Saxons, right, before the conquest, right? But generally, you've got, Magna Carta and the Charter of Liberties and Magna Carta and so forth. Now, the observation of due process of law, 1368, right? Now that creates, there's on the Parliament website, when they've got that Act of Law written out, they say the Commons, but it's meant to be Old French Norman, which is the community petition the king, right? Now, you didn't always have a Parliament. In fact, they only had a Parliament a small amount of time, right? So you didn't have MPs. So you don't have any MPs elected unless you call a Parliament and then they go to represent you instead of us representing ourselves directly to the king, right? So you've got observation of due process of law to the king or Parliament, right? And there were certain rules in that because people were making arrests and abusing and misusing it, right? So they made it so no one gets arrested until the matter has been submitted officially in writing to Parliament, and then the committees direct the proceedings. But obviously you need some sort of evidence, right? But you're not meant to go apprehend anyone, but you yourself aren't meant to be arrested either. You're not meant to be arrested and you don't arrest anyone else, right? The police don't intervene, okay? That's, in my opinion, that's the basis of it. Now, but you've also got the courts as well, and you've got the Statute of Westminster 2, right? And you've got Article 31. Now, that is a bill of exemption. Now, you've got the courts, you've got the court circuits, right? How am I going to draw this? You've got the court circuits going around the country, right? But they go to Parliament. They finish up at Parliament. They go around the country, right? Now, you've got your local petty sessions, and then you've got the assizes and quarter sessions, and then you've got like the Westminster Hall and the King and Council. Now, if you disagree with a judge, right? If you disagree with a judge on and argue on the law, what the law means, you disagree with the judge on it, or you've got a right which they refuse to recognise. Not on anything else, like, on the evidence or the decision of the judge on what did or did not happen based on witnesses, what witnesses say, right, or the jury verdict. We're talking about purely on, what the law is. If there's an argument over what the law is, or if someone brings out some fake law and they might think it's not real, so you want to go get it checked, right? You've got the power from the Statute of Westminster II, which I think's around 1270 something. It's around the confirmation of Magna Carta time, just before the confirmation of Magna Carta. 1280, I think it's 1285 or something like that, right? You can complain about a judge, and he or another judge has to sign the complaint or seal it. He cannot refuse. If you disagree with him on something, he cannot refuse. And that matter, you send before the king, and he calls the judge, and they check it. And then they come back and do whatever the truth of fact is, if you believe that, even the king's not going to, break his oath and not going to lie, right? So you've always got that right. So you've got what you've got with that is if you've got a connection, right, a line directly to the king himself through the courts, which cannot be obstructed. You've got a legal connection to the king if you dispute a judge cannot obstruct it, right? He must, in fact, you will order a judge. You order, you compel the judge, you order, you command the judge to sign it, right? And he must obey you, right? When you petition the king over interpreting your own rights and legislation through the courts, right? Now, you don't always have a parliament, so that always goes through to the king anyway, right? And the circuits usually go round through the counties and back to the king and council anyway at the Tower of London, right? Now, sometimes you have a parliament and sometimes you don't, right? But the observation of due process of law is the right to petition Parliament or the king, depending on if there is a parliament, you have one, and if there isn't, you don't, right? So parliament or king, whoever, right? You've got a legal right to do that. Now, when you do that, you are removing yourself from local court jurisdictions, right? So the petty sessions is not going to hear it. The assizes on quarter sessions are not going to hear it because you're going directly either to the House of Commons or Lords or to the King and Council, right? And that is why you can't, you're not liable to be prosecuted in the courts, right? Now, the King himself could have these Court of Royal Commission or the Star Chamber or the King and Council or even like in Westminster Hall, right? A King's Bench. They aren't the petty sessions and they're not the assizes and they're not the quarter sessions, right? Now, the King, because it's the jurisdiction in which you're bringing it in, right? And you're not liable to these ones, right? And you're not supposed to be. He was sometimes you're always when you do this observation of due process of law, you're in the jurisdiction of whichever authority it's to, whether it's the House of Commons or Parliament, Lords, or the King Privy Council, right? Not in these jurisdictions. So these jurisdictions don't get involved. And that's the difference of jurisdiction now, right? But, so once you're in this jurisdiction and not the others, the king sometimes, so this is like, they're not going to prosecute you no matter what you do, right? Because it's not their business. But the king was prosecuting some people, even though it wasn't the other court's business, in his court, for some of the cases that you were bringing that he wasn't too happy with the things that people are asking, like religious things or to do with the church or whatever. And this is when you get people getting prosecuted for merely bringing a case, right? Like William Prynne or Henry Burton, like when they got their ears chopped off, right? You know, and then the wives were petitioning for them to get released from prison, like under John Pym. This is why they abolished the Star Chamber and, Court of Royal Commission and things like that, right? But even if the king prosecuted them or not, it is that you're not going to get done by the sheriff, pay sessions, quarter sessions, or assizes, because it's not their business. You've taken it higher, right? So, now this is when you get the update to the observation of due process of law, which is the 1688 Bill of Rights. That is the right of the subjects to petition the king, and all prosecutions against you are illegal. So the king can't prosecute you for even daring to make the claim or bring the case, no matter what it's about. But all prosecutions were already not to be brought from the sheriffs in the pay sessions local county area or the assizes or quarter sessions, because it's not in their courts, it's in a different one when you're bringing a case and collecting evidence and making representations. So the 1688 Bill of Rights, that it's illegal to be prosecuted, obviously Obviously, you're not prosecuted by the police in the local petty sessions, magistrates court, crown court, assizes, county court, etc. Because you've already gone to higher court. You've already got a case in higher court with matters to do with that. But also in the 1688 Bill of Rights, yes, all prosecutions from these are illegal anyway. But they're just reminding you of that. And the king can't prosecute you. Now, they didn't always have a... You also then, whether you've got Parliament or you don't have Parliament or not, but that doesn't really matter too much in this context. Now, this is the thing with Parliament, right? So, around 1868, right, all of the petitions to Parliament, House of Commons or Lords, right, there were all different types of petitions over all different things. Complaints against MPs, petitions asking... So all of the different petitions went to Parliament, all of the different ones, whether it is for an election petition or whether it is against an MP if they've done something wrong, or anything that Parliament might be doing wrong because you want them to be impeached, because it can't be heard in any court or place out of Parliament here. So you have to petition it to Parliament, not these places, right? And any local grievances which didn't get sorted out in these courts also went there, but also making and changing of the laws and the taxes. But there was some local taxation issues dealt with in the local courts, but we're talking about getting bills made or for the whole country, not just the local area. If it was for the whole country, not the local area, right? Or even if you disagreed with a local authority. Now, this is when the kind of modern sort of period is changed, because they take the election petitions for elections out of Parliament, right? And they get dealt with by an election court, which is kind of like under this thing, but I'll put it here, right? The election court is here, right? So people aren't sending petitions into Parliament about elections, but there is actually still a right to have it in there if it's not about one seat, because they're normally for one local area. Now, there is an argument that that made a new privilege for the judges and made a new privilege for the MPs, that they didn't have to deal with those petitions, right, under the 1704 resolution. But that's a separate argument. So that's 1868. And then when we get to 1967, the petitions to Parliament about like local government departments like the NHS and the police or the Inland Revenue or a Department of Transport, they also, you stop petitioning Parliament in the traditional sense about those as well, because then you've got the Ombudsman, right? But MPs they made a special act of law to deal with that, but the MP still signs it off as if it's a normal petition, but instead of Parliament committees dealing with it, the Ombudsman deals with it, right? So you aren't getting election petitions aren't going to Parliament, and the Ombudsman, ones about government departments aren't going to Parliament. And then I think it's 1995, then you get but they're still getting complaints about MPs and really impeachment as well if they've misbehaved, because you can't get it dealt with in here, right? You've got to get it dealt with in Parliament. And that is when they had the commissioner. So the House of Commons commissioner then is taking petitions about misconduct of MPs, not in elections, but misconduct of MPs just generally in Parliament and when they're doing their job, right? So what's actually left in petitions? Well, then in 2006 or 2008, I think, Tony Blair makes the number 10 Downing Street e-petitions website, right? But all what's really left then is petitions about asking to get laws made and changed. But people do that through private bills anyway, right, if they want, or political parties do that. But it's just if independent people want to make any suggestions or ask for something. But in the standing orders of Parliament, nothing has changed in what the petition can be about. They've only made these for convenience, really, and something extra, and funding it to deal with it. But they're still meant to be for the same thing. And then they're trying to make out that we don't have protections and privileges for these processes when we actually do. So they're like trying to get the whole petitioning thing out of Parliament. Now, the thing is that in the 1688 Bill of Rights, it says Parliament is there to redress grievances and amending and strengthening the laws, and that's in constitutional right. But they've got all this redress of grievances put off to the courts, to the ombudsman or the commissioner, right? But they cannot actually stop you petitioning about that because it's in law and it's still in standing orders. And then this is when you get this e-petitions policy, which they make out that they're not going to publish or air them. Yet, in some of these reports they said it's very important to air the grievance, whether great or small, and spread awareness of it, which this does not do. Because you're not collecting loads of signatures about it and telling people about it. When you submit it, you just submit it and then apparently they sort it out. But you're not actually compelling them to act with great numbers of signatures if they don't want to do it. And you can't force them to do it by great numbers of signatures. So it really, we're being jipped off with it.